Welcome, everyone. I'm Doris Epstein, co-chaired Toronto of the Canadian Institute for Jewish Research. Welcome to you all. Canada has a massive anti-Semitism problem, and the lack of response to this terrible situation has mystified and shocked. Across Canada, hateful rallies are held freely, targeting Jewish institutions and Jewish communities. There have been few arrests for even attempted arson at synagogues and shootings at children's schools. Schools allow violations of policies that create a toxic environment. Jews across Canada are feeling bullied, isolated, harassed, and frightened. There should be direct, immediate legal consequences for illegal and threatening behavior, but response from the government has been feeble at best. How do we deal with this? Mark Sandler is one of Canada's leading criminal lawyers. He's lectured extensively and trained police and prosecutors on legal means to combat hate. He's appeared many times before the Supreme Court, House of Commons, Senate committees on anti-Semitism and other forms of hate. Because of the escalation in anti-Semitism after October 7th, Mark founded the Alliance of Canadians Combating Anti-Semitism, ALCCA. It's a coalition of more than 56 organizations. But first, a few words about CIJR, who is bringing you this webinar tonight. The Canadian Institute for Jewish Research. It began over 35 years ago in Montreal, headed by a group of professors led by Professor Fred Krantz. Actually, it started in his basement. They were witnessing rampant anti-Semitism on Montreal campuses. So they began organizing speakers, making publications, symposium, conferences, anything and everything to fight the misinformation and biases against Israel and the Jewish people. And it's unfortunately a goal that continues to this very day, but with even greater urgency. Through CIJR's publications, such as the Daily Briefing, you can depend on in-depth, fact-based analyses of Israel, Jewish culture, and world politics, information and news that you'll never find in mainstream media. Let me remind you that ours is a non-for-profit organization, and our work with students and for Israel is entirely dependent on your tax-free donations. So now, enough is enough. How you can use the law to fight anti-Semitism with Mark Sandler. Get your questions ready and have lots of them. This is a hot topic. Mark, over to you.
Thanks so much, and thank you to the organization for inviting me. I've been looking forward to tonight. So on we go, and I'm going to start very, very briefly by telling you about the Alliance of Canadians Combating Anti-Semitism, because it's a natural segue for our discussion about the use of the law. As you've heard, it's an alliance of now 56 community organizations, many of which will be familiar to those who are here tonight. And originally, it was organized to respond to the House of Commons hearings on anti-Semitism that were taking place before the Justice Committee. And we filed 40 briefs on all different aspects of anti-Semitism, including what we saw as the underuse of the law to combat the anti-Semitism that was taking place. And another several reasons why the organization was created are as follows. And the first is, and some of this will resonate with you, some of it you may disagree with, but in my experience fighting anti-Semitism, and unfortunately, I've been at it for about 40 years now. It's been my experience, as I said, that we don't always collaborate in the work we do in fighting anti-Semitism. Organizations operate in silos. Sometimes they even operate competitively. And I believe that our adversaries are more collaborative in their approach to the issues and unified in their messaging, however offensive, than we are at times as a community. So one of the goals of this alliance was to build some partnerships going forward. The second concern that I had was that we weren't sufficiently relying upon our non-Jewish allies in making the case for anti-Semitism. All of you have either said or heard someone say that anti-Semitism doesn't stop with the Jews. We are the canary in the coal mine, so to speak. But what that means is that we have to mobilize members of the non-Jewish community to speak out about anti-Semitism and hatred. So our alliance includes Indigenous leadership, Catholics, members of the Hindu community, members of the Iranian community, Catholic community, and a number of others, because in my view, it is critically important to build those kinds of alliances and have those voices be heard. The third reason why I created the coalition was, again, frankly, one that you may agree with or disagree with. And I find that there are a lot of organizations endeavoring to do their very best to fight anti-Semitism. But what we need is an evaluation as we go as to whether the measures we're taking actually produce success. Sometimes these measures make us feel good because we're fighting back against an evil force. But we always have to be mindful of whether or not the steps we take are producing quantifiable or measurable successes. And again, that means national strategies. That means collaboration. That means setting aside competitiveness in favor of a common approach. And we won't always agree on every strategy that should be employed, but we really have to do much better in this area. And it's one of the themes that I'm going to present to you today, because I'm going to describe to you two measures that I think will significantly change the way the law is applied in Canada. And I'll come to that in a few moments. So I described the organization, and my only plug tonight is that if you go on the website, www.alcca.ca, every Sunday we do a newsletter, and the newsletters are a little bit different than what you're normally seeing, because they include detailed analysis, often of the law, and often calls to action as to what you can specifically do to address anti-Semitism. So, not surprisingly, I commend the newsletter to you, and I hope that you will all become subscribers. It's free, no donation is required, and you will receive them at least once a week and periodically when events occur of importance. So now let's talk about the law. I was schooled in the law. The law has formed so much of my life for the last 45 years. And in my view, the law is an important tool, indeed an indispensable tool in combating anti-Semitism. And I say that in several contexts. The first is the use of criminal law. In my view, we often hear people tell us that we need amendments to the Criminal Code of Canada in order to be effective in combating anti-Semitism. In other words, we would do more, but our hands are tied by the inadequacies in the criminal law. My friends, it ain't true. There can be changes to sharpen the criminal law in several areas. For example, the creation of an offense that exists in other countries that criminalizes the possession of terrorist symbols. But in my view, the law is quite adequate as it currently exists to investigate and prosecute hate activities when they are taking place. I repeat that. The law is perfectly adequate if the will exists to use it and knowledge exists as to how to use it to successfully investigate and prosecute hate activities that are happening across Canada. And I look at the full range of tools that are available under the criminal code to combat hate. So there's a lot of talk about the hate speech sections of the criminal code, and we have 4 of them. We have the willful promotion of hatred. We have advocating genocide. We have incitement of hatred likely to lead to the breach of the peace. We have advocating or promoting anti-Semitism, specifically Holocaust denial or minimization of the events of the Holocaust. Those offenses are important tools in the arsenal, but there are so many more available to us that are being underutilized. So I'll give you an example. How many times have you heard people say that there's nothing we can do when protesters who are saying hateful things are blocking our roads, taking over our intersections? There's actually a specific section of the criminal code called intimidation that addresses the blocking of roads and highways and tunnels and bridges, specifically addresses that danger. We hear about the offense of mischief, which involves vandalism or damage to property. But mischief also involves the interference unlawfully with the use and enjoyment of property. And it can apply to an interference on public property and on private property. And in so many instances, this provision would be fully available to address some of the hate activity that we are seeing on our streets and on our campuses. Unlawful assembly is another offense that is underutilized in the arsenal that is available to police and to prosecutors. And I could go through the list of offenses that are available, but suffice it to say, one of my tasks is to ensure that law enforcement across the country fully understand the range of offenses that are available and don't simply place emphasis upon the more difficult cases to prove and the more complex cases to prove, which are the ones under the hate speech provisions that I outlined before. Now, that's not to say that the hate speech sections are being utilized to full effect. On the contrary, we are now starting to see the use of these provisions to deal with anti-Semitic speech. So there was a successful prosecution, for example, in Quebec, where the accused received a 5-year term of imprisonment, where this section and other sections were utilized. We just saw a case successfully concluded before a jury in Brantford that involved the willful promotion of hatred against Jews. We've just seen the other day 29 charges laid against an individual that included advocating genocide against Jews. So we're seeing now a greater use of these provisions in order to move forward. But again, they've been underutilized, and they've been underutilized in part because we need to educate police and prosecutors to a greater extent as to what constitutes hate speech as opposed to what constitutes protected speech. Because How often have you heard, again, a political figure say that we have to fully respect freedom of speech, freedom of assembly, as long as it doesn't involve hate? And my answer is, I agree. Freedom of speech, freedom of assembly, including the freedom to take positions that are critical of Israel. Um, I mean, these are the kinds of things that are protected under our Canadian Charter of Rights and Freedoms. But what we're seeing in many protests is a crossing of the line. And I say a clear crossing of the line between protected speech, which includes robust criticism of Israel, its policies, its conduct, its government, um, West Bank settler extremism, what have you. And even the IRA, the International Holocaust Remembrance Alliance's definition of anti-Semitism contemplates robust criticism of Israel to the same standard as is applied to other countries as not being anti-Semitic. But what are we seeing on our streets? And what are we seeing on our social media? We see death to all Zionists. All Zionists are genocidal, evil. We see not only from the river to the sea, Palestine shall be free, and various interpretations given to it, but we see from water to water, Palestine shall be Arab, which is quite unequivocal in its language. We see chanting that talks about global intifada by any means necessary, which is unequivocal in my view. We see the bearing of flags and symbols of terrorist organizations that have been declared as such by the Canadian government. And we see similar kinds of chants, not only on our streets, but we see this language parroted on our social media and on our campuses. And in my view, you do not get immunized from criminal liability because you use the term Zionist simply as a proxy for Jew. And that may be one of the most important points that I can make in speaking to law enforcement and prosecutors and government officials, because they have been told, or they believe at times, that if people are talking about Zionists, then they are immunized from any criminal culpability. And let's remember that 91% of Canadian Jews are Zionists. So again, I'm not the slightest bit interested in prosecuting someone who comes to a rally and criticizes Israel, criticizes its conduct, criticizes its government, criticizes the conduct of the war in strong language. I may be offended by it. I may disagree with it, as I do, but it's protected. But when we're talking about demonizing people simply because they support the existence of the state of Israel, when we're talking about demonizing without any distinction all Zionists as evil, genocidal, and racist, then how is that not constitute hate speech under our criminal code? So you're asking the question as you're listening to me, so why hasn't more been done to prosecute these cases? I can't talk about all of the cases that are under investigation or the subject of prosecution. I do believe that through training and education, we are seeing the lights go on in some jurisdictions as to how these cases should be dealt with. But this is what we need in order to be effective. First of all, we have to do a better job of separating out what constitutes protected speech, even if we disagree with it, from hate speech. If we treat every protest as a hate crime, if we treat every offensive social media platform expression as a hate crime, then we lose credibility as a community. So I focus on the ones that are most egregious, that involve those who are extremists, and that is an important step in addressing this. Second of all, education. Police have to understand the full range of measures that are available to them, and I've told you a little bit about that already. Third, they actually have to understand what contemporary anti-Semitism is all about. If they're taught about the tropes, the stereotypical tropes about Jews that have existed since ancient times, as helpful as that might be in the abstract, we are dealing with a particular type of anti-Semitism now that is tied to anti-Zionism. There's no two ways about it. And you see the resistance to the IRA definition of anti-Semitism. Why is there such resistance to it? Well, there are some scholars that take issue with the language and whether it's over-inclusive or under-inclusive. But at the heart of it, many people who object to the IRA definition and the illustrations of anti-Semitism in the IRA definition object to it because it identifies anti-Zionism as inextricably interwoven with anti-Semitism. So when the Prime Minister of Canada says that he's a Zionist and says that Zionist shouldn't be a pejorative term, what we're seeing is the normalization of Zionism as a pejorative term. And again, and I repeat for the third time to emphasize the point as strongly as I can, don't let somebody tell you that we're just interested in suppressing pro-Palestinian commentary. Protest to your heart's content about conduct, about government, about policies. But when you demonize all Zionists, and therefore 91% of Jews, when you call for the elimination of the very existence of the state of Israel and deny any right for Jewish self-determination, you've crossed the line. And police have to understand that, as well as prosecutors and ultimately judges. What else do we see? We also see a misunderstanding of what de-escalation is all about. So in some police forces, they believe they've been successful if they keep the pro-Hamas group separate from the pro-Israeli group, and that nobody is injured, and they say we've de-escalated the situation successfully. Well, the problem with that approach is that if you give full license to pro-Hamas protesters to preach hatred, not simply criticism of Israel, but the kind of hatred that we talk about, even the Supreme Court of Canada has recognized the harm that's caused to the Jewish community by allowing that kind of hate to be expressed. It marginalizes the Jewish community, and it also encourages like-minded hate mongers to act upon these hateful sentiments. There's a reason why they're expressing these views. They wish to gain adherence to their cause. So when you simply say, we've been successful because nobody was immediately injured, the hateful comments are injurious. And the Supreme Court of Canada has said so in upholding the constitutionality of the hate speech sections of the criminal code. So take all of that and let's apply a new lens to what it is that we're dealing with. First of all, leave aside protests for a moment. We have extremists. We have jihadists in our midst. We have terrorist entities operating sometimes with impunity in Canada. And we need a collaborative effort on the part of law enforcement at the national, provincial, and municipal levels in order to address this extremist threat. So we're working on foreign financing issues of protest activity and other extremist activity. We're working on the extent to which money laundering of extremist organizations is taking place in Canada. And we are soon to announce an initiative that, in my view, will be an important one in more fully addressing the criminal law. And that is that ALCCA has organized, under the leadership of Rochelle Dierenfeld, who was a prosecutor for 32 years with the Ministry of the Attorney General, and for 6 of those years, a member of their hate crime working group, a cadre of senior criminal lawyers across the country. And we will soon announce, within the next few days, a partnership with the Canadian Jewish Law Association, which is a brand new association that operates at a national level to bring together Jewish lawyers across the country for the first time in an organized, collaborative way, and with CIJR in a tripartite partnership to triage criminal matters that the community brings to our attention, to reach out to law enforcement to explain why these are or are not hate crimes or allegations of hate crime that should be investigated, to provide support to victims of hate crime, to provide legal advice and legal counsel in circumstances where it is needed, and to assist in educating police and prosecutors right across the country about the kinds of things that I've talked to you about today, and also about how the IRA definition of anti-Semitism should form a critical tool for police and prosecutors in informing their approach to hate crimes. Now, I've talked a little bit about criminal law, and frankly, I could talk your heads off for hours about criminal law because it's where I spend a great deal of my time. Much of what we do, I won't talk about, and that's okay. That's okay, because for me, it's very important not to imperil cases that could come before the court or are before the courts. So if it means that little less attention is given to our work, that's the way it should be. We have to measure our successes in appropriate ways, rather than undermining the very work that we're attempting to accomplish. Now, I'm going to tell you about another concern that I have and how it is being addressed. And that has to do with non-criminal litigation. So for me, the law is an important tool to use not only in the criminal context, but also in the non-criminal context. And now we're talking about suing organizations, whether they be universities, unions, specific individuals, faculty, what have you. And these lawsuits can take a variety of forms and can proceed in a variety of forums. But what I have seen, and this is not to denigrate the great work that has been done by a number of organizations, what I have seen is that we have placed inordinate weight upon pro bono lawyers to be carrying this kind of litigation in Canada. And I've also seen that there is no national strategy for how specific kinds of cases are being dealt with. So we'll see a lawsuit against one university when maybe 6 other universities would be the subject of the same lawsuit. We've seen gaps in the use of litigation to address what we know are obvious breaches of codes of conduct. And we need a new model for how we approach non-criminal litigation. So again, soon to be announced will be a partnership involving UJA, CIJR, and ALCCA, and the Canadian Jewish Law Association. And the idea behind it is very much modeled on what is going on in the United States. Many of you read about the Harvard lawsuit that was brought against Harvard for failing to protect its Jewish students and failing to comply with its own policies in protecting Jews from hatred. And the model, that lawsuit was carried in part by the Brandeis Center, which is a nonprofit organization devoted to the conduct of litigation. So we hope to model that here in Canada through a national strategy. So what will that mean? That will mean that we are creating a group of the top lawyers in this country to meet as a subcommittee and to decide what cases should be funded in the pursuit of public interest litigation on behalf of the Jewish community. And the idea will be that through funding, and it won't be at full commercial rates, but it'll be at reduced rates, but it'll enable top flight lawyers. And there have been some good ones doing the pro bono work, but it's not sustainable in the long run. It will enable lawyers, top flight lawyers, to proceed on complex, lengthy, important, precedent-setting litigation to advance the Jewish community's public interest and to address the scourge of anti-Semitism in a much more powerful way than currently takes place. I'm excited about this. I think it could be a game changer. And look forward to the announcements that'll be forthcoming about it in the near future. We're working hard to create it as a national strategy. And what I hope it'll mean is that we'll also bring together every litigator who's working in this area so that we can share our experiences about what's working and what's not working. Many people in the Jewish community don't even know what litigation is being advanced on their behalf. They say there's no litigation, nobody's doing anything. It's not so. It's not so. There's not enough of it, but you don't even know what takes place nationally. So for me, it's important to create transparency for the Jewish community so you know what litigation is being advanced on your behalf. And it's important to have top flight lawyers deciding on what should be litigated. And it's important that the litigation be supported by funding, because that is a way in which we can be most effective in creating a national strategy. And then the last point that I want to make, because I'd rather answer your questions really than lecture, is this. Some people say to me, you know, the answer isn't the law to all of the issues of anti-Semitism that exist. And I say, you're absolutely right. So for those of you who have heard me speak before, my apologies that you're hearing me yet again, but for those of you who have heard me speak, you know that I say something over and over again. In my view, the law is an important tool to address extremists and those who facilitate their activities. Education is important to address the ignorant and the misinformed. And respectful dialogue is critically important in order to speak to those who have different, very polarizing views about the issues. And I'm prepared to speak to anyone as long as they don't seek my extermination or the extermination of my people or deny the very existence of the state of Israel. It's a pretty low threshold for conversation. And it's not for everybody. It's not for everybody. But for me, I'm prepared to talk to people who don't celebrate barbarity and violence, who want to seek some sort of reconciliation, who recognize a common humanity and recognize that there's more that that joins us than separates us. Difficult task. People say it's impossible to do while the war is waging in the Middle East. And I say it's never been more important than when war is waging in the Middle East. So you'll read about the respectful dialogue initiatives that are taking place as we speak. They're in the embryonic stages. I've been very much encouraging the legal profession to take the lead here, because what do we do as a legal profession? We operate in an adversarial system, but in civil discourse with each other. And that is a model that we have to employ in order to have further success. So use of the law, hard-hitting law, to address these issues, and particularly extremist, through criminal law, through public interest litigation or lawfare, the use of education like never before, because so many people in the community have been misinformed or are ignorant about the facts on the ground, and respectful dialogue, as painful as it is, in order not to persuade people to my views. They can disagree with my views, but to reduce the levels of demonization. So students in K to 12, students on university campuses, employees, union members, faculty, teachers, they all should feel free to be able to announce that they are Zionists, that they support the existence of the state of Israel without being demonized, without being demonized. And we have to get away from the indoctrination that is taking place on campuses and in institutions and in schools that tells a one-sided narrative of the events. Now, I've covered so much ground in a half an hour. You'll have so many more questions than answers as a result of that presentation, but I wanted to give you a little bit of an overview, knowing that Doris has received dozens and dozens and dozens of questions, and I tend to answer any question that you might wish to ask me. So that's a little bit of an overview. Doris, over to you.
Okay, here goes. Okay, we have all the laws we need. We don't need more laws, according to you. Then why, and it's not ignorance, it's not lack of knowledge. Why have there not been arrests for all these charges that they could have been arrested for? Why? Who do the police take their orders from? That's the
Okay.
real question.
Okay, so here's the answer, and it depends on the jurisdiction. For example, in Ottawa now, we are seeing the police, with the guidance of the local hate crime prosecutor, take the lead in addressing criminal code violations in that jurisdiction. So why in Ottawa and not elsewhere? For me, one of the answers has to do with small p political will. And by that I mean that it's not good enough to have education on anti-Semitism, education about the law, coordination between police services, resources offered to the hate crime unit. Those are all very important, but you have to have the political will to carry these cases through. And what that means is we have to start with our municipal officials. Municipal officials do not direct the police as to the day-to-day operations. Like, you will be told that over and over again. So they'll say, we are helpless to address the situation. I respectfully disagree. First of all, municipalities create policies, and those policies must include zero tolerance for anti-Semitism. They must include an acknowledgement on the part of municipalities that say that anti-Zionism, demonizing all Zionists because they are Zionists, is unacceptable in our municipal spaces. Municipalities have to pass bubble legislation, which is legislation that limits the right of protests to operate in close proximity to vulnerable community places of worship, community centers, and schools. And don't let anyone tell you that bubble legislation is unconstitutional. It does not impair in any substantial way the right of protesters to protest about Israel and all of the issues that they wish to raise, but it protects vulnerable communities from having to be subjected to this and interfering with their ability to enjoy and use their places of social infrastructure. So I've written about this extensively. I give full credit to the city of Vaughan and its mayor for taking the initiative. We now see Oakville is considering the bubble legislation. We've seen a number of municipalities now introducing it. I just wrote about this and why it's constitutionally permitted. We need to see municipalities being more active. And we need to see municipalities do what they're fully entitled to do constitutionally, which is ban hate fest on municipal property. So we now have upcoming Al-Quds Day, which is a day that was created by the Ayatollah in Iran that is basically a hate fest. And we've documented how it has been used as a vehicle to support terrorism, to martyr those who have died who are terrorists, and the like. And we need municipalities to acknowledge that we're not interfering with freedom of speech or freedom of assembly, or we're doing it in a minimally intrusive, constitutionally protected way by saying we will not allow a hate fest to take place in our city. So it starts there with municipalities. It also starts with the provincial government, because the provincial governments and territorial governments are entitled, again, to reinforce as policing policies. They're not directing day-to-day operations, but they're creating policies that say zero tolerance for hate. And we need the message from the federal government to be a consistent one, not an ambiguous one, not one where one thing is said to one group and another thing is said to another. Everything that I have said so far should be unchallengeable, should be uncontroversial, but it isn't. So for me, the answer to your question is, why haven't we seen more? I think we are going to see more this year from some jurisdictions based upon education and training, based upon hammering home the messages that I've been outlining, based upon some courageous mayors that are taking leadership and some counselors that are taking leadership in addressing these issues. but these are the points that have to be reinforced if we expect more to be accomplished. Last thing I want to say is that the Jewish community thinks that no charges have been laid in these cases. I hope that with the creation of our Canadian criminal law working group, that we are going to create a vehicle so that charges that have been laid and are outstanding are transparent for the Jewish community to see, so that they can measure, what is being done and what isn't being done to address these points.
Could charges be made against the municipal government for allowing Al-Quds Day? Theoretically, could that happen?
So these discussions are taking place, not criminal charges, but
one of our viewers has noted for 10 years, Doug Ford has promised to take Al-Quds Day off the streets. And for 10 years, we haven't.
Well, it's time to create the political will for it to be done. There's no excuse for not doing it. And the answer isn't charges. The answer is a combination of political will to do the right thing, which has been lacking in so many jurisdictions, but also consideration given to whether or not there can be lawfare associated with the breach of obligations to the members of the community to keep them safe. You see, for example, Toronto has a policy against allowing hate fests in this city. Enforce your own policy, Toronto City Council. Right?
But is that a case? Isn't that an obvious case for litigation?
So I'm very reluctant to talk about litigation that may take place or is
hypothetically.
pending.
Can you talk hypothetically?
Well, hypothetically, I think that we're going to see what happens on Al-Qaeda's Day this year. And if we don't see any change, then I think one of the things that should be considered, quite frankly, is the use of litigation to attempt to compel governments to enforce their own policies. It's time.
Could the IRA definition of anti-Semitism become the legal definition against which to charge people for Jew hatred?
So not only could it, but when the IRA definition was adopted by 43 countries, including Canada, it was said that it's not binding. And I understand that, but it's a tool to be used in the arsenal of law enforcement to inform whether charges should be laid. We've had one case so far, a private prosecution that ALCCA's senior counsel, criminal counsel, initiated, where the judge relied upon the IRA definition in order to support the successful prosecution. We need to see greater use of the IRA definition. And the Canadian government has adopted it. They've said that it should be incorporated into training across the land. And that's our task this year. It's one of our many tasks, is to ensure that the training and education includes not only the IRA definition, but how it should be employed to full effect to inform decisions being made about cases.
Good. Okay. My college in Toronto offers a course packed with anti-Semitic content. Help.
Okay, well, for the person who submitted that question, I don't know enough about which college, which circumstances, because we have, for example, a task force that involves a number of our member organizations that has been working on remedies at 2 of the universities. I just wrote a piece about the University of Toronto, and in my respectful view, I am unpersuaded that there'll be significant change at the University of Toronto in the absence of litigation. So, so the answer to the help is help has been on the way in a number of the colleges and universities, but we're also playing a game of whack-a-mole. I'm going to be completely candid with the people who are on the call. There's a lot of hate going around. And so we're trying again to create a national strategy where we can piggyback on work that's being done in one jurisdiction in order to provide support in another jurisdiction. So, for example, I commend those, including NECA, the Network of Engaged Canadian Academics, one of our member organizations that were very active in fighting against the boycott, the BDS movement at Queen's University, and the effort to cause Queen's to divest itself from Israel or activities in Israel. And the committee that evaluated that at Queen's just this past week issued a report that vindicated our position. Namely, this isn't about whether Queen's supports Israel, doesn't support Israel. This is about academic freedom. This is about institutional neutrality, which is what universities and colleges should be all about. This is really about research integrity, where researchers in Canadian universities and colleges want to work with their Israeli counterparts in order to advance research for the benefit of everyone. And this report was an important blow to the BDS movement, and we need to utilize that as a precedent across the land to deal with the BDS movement as it springs up in universities. So that's how you leverage, you obtain success, and then you leverage that success and try to utilize it across the country. That's what a national strategy is all about.
President Trump defunded Columbia to the tune of $5 million. And also, several academic departments are being revamped. Can we do the same thing here?
So the answer is that I prepared a discussion paper for the federal, provincial, and municipal governments on what I saw as actions that can be taken to combat anti-Semitism. And I suggested that universities and colleges could be defunded by the provincial and federal government, both of which contribute to universities, if they fail to take measurable steps to address anti-Semitism on their campuses. I won't comment on the scope of what President Trump's doing in the United States and the like. I know there's a natural reaction in the Jewish community to say right on, because Columbia has been a cesspool of anti-Semitism since October the 7th of 2023. But rather than comment on the specific measures that Trump took, I think that measured defunding or conditional funding, which is what I emphasize, conditional funding based upon shown measurable success in addressing anti-Semitism, should be in the toolbox. Absolutely.
To continue on, can we shut, what can we do about online lies and disinformation attacking Israel and Jews? And another question will collapse into this one: is a screenshot with a cell phone ample evidence if you take it, a picture of it on social media?
So answering the last question first, yes, a screenshot can afford evidence of the content of what's on social media platform. We now have several prosecutions that have been successful in relying upon social media commentary to prosecute. And there are certain cases that are before the courts now where the prosecution is relying upon anti-Semitic social media in order to prosecute? So the answer is that if you see things that clearly cross the line and constitute hate speech and you take a picture of it, that's an acceptable way in which one can bring that to the attention of the authorities or the Canadian Criminal Law Working Group when it gets underway within the next week. In terms of what can be done about social media, one of the things that we are doing at ALCCA is we are creating a social media task force with experts on social media, because I don't pretend to be an expert on social media. And we're bringing them together to discuss that very topic, Doris, about what more can we be doing to address hate on social media platforms. One of the challenges for it, and I had dealt with this issue 30 years ago, one of the challenges has been jurisdictional. The extent to which some of the social media commentary originates in other jurisdictions and poses challenges in terms of law enforcement. So one needs to address these things through international presence, not simply Canadian presence. But we have enough homegrown Canadian hate on social media platforms that's not a complete answer. For me, the other thing that's important is tracing the financial support that's being offered to enable these social media and some protests to be taking place. And I think you will hear this year some of the reporting that's now being worked on the extent of foreign influence, financial and otherwise, on activities that are taking place in Canada. And again, I'm hoping that that will mobilize action on that front.
Back to universities and money. ISCAP, Charles Small and a Canadian, Michael Bass, did a remarkable research job. Follow the money. Are you familiar with that?
Not only am I familiar with that, but I have spoken to Charles a number of times because the same work is being done in Canada right now. I can't say more about it.
But Michael Bass told me that we can't do the same thing here because it's not transparent. They won't reveal who gives money to the universities.
Well, yeah, I don't want to talk about it more extensively, except to say that work is being done in the area, and one of the things that may come out of it is the need for greater transparency as to the sources of financing to universities and colleges. So, but I'm not going to say that it's impossible. That's not the sense that I'm getting.
That it's not impossible.
That it's not impossible to draw some important inferences about foreign financing. But again, we'll have to await some of the scholarship that's currently being done in the area.
Question: how could we have protected ourselves from the vitriol coming from the McGill, you could say University of Toronto, and other occupations, when the police simply stood by?
Well,
and people, let me collapse that into other questions. People say, what do we do when we're at a crowd, when we're at a protest, and we hear all this hatred, and we see swastikas, and we hear talks of Israelis being Nazis, on and on. What can we do?
So what you can continue to do, and it's with some level of frustration, because if I were to identify the jurisdiction which is most problematic in addressing anti-Semitic hate activities, it's Montreal. And the police have passed on a series of charges which should have been laid. In my view, the lack of political will is self-evident from the mayor down, and we have to see a real change dynamic in what's happening in Montreal. One of the things that we intend to do is we are giving consideration to proceeding on private complaints rather than dealing with them through the police. There are limitations on the use of private complaints in order to be successful. But on the other hand, it sends a clear message to police, which is if you won't do the job that you are empowered to do and are duty bound to perform, then we will proceed. So we're considering some remedies to address it. In my view, it has to start in Montreal as well with the appropriate education and training, because I don't think the Montreal police have received the kind of education and training that has been provided now to a number of police services across the country. And I think you're going to see a difference based upon that education and training.
Halavai.
Halavai.
Many viewers have asked this question, and with due concern. How do we prevent anti-Palestinian racism, and how do we prevent them from taking root as legal definitions? Anti-Palestinian racism, which absolutely knocks out IRA.
Okay,
destroys
so
IRA.
This is a topic that I've spoken quite a bit about, and there's soon to be a piece that'll be publicized that a number of us have authored that addresses directly anti-Palestinian racism. Let me explain to your listeners who are otherwise unfamiliar with this what this debate is all about. So I want to be clear. I am very much against discrimination, whether it's against Palestinian Canadians, Arabs, Muslims, or Jews. We have no tolerance and should have no tolerance for discrimination. But what we are seeing is something quite insidious, and that is that the concept of anti-Palestinian racism is being introduced as part of anti-racism programming. And the proponents of anti-Palestinian racism have defined it largely in a way that basically makes anyone who supports the existence of the Jewish state a racist. In other words, they've employed a definition that is racist in order to purportedly protect Palestinians from discrimination. That cannot survive scrutiny because, as you say, not only is it incompatible with the IRA definition of anti-Semitism, it's incompatible with basic anti-racism training. You're not training people to demonize another people. You should be training people to respect diversity, respect all people regardless of their national origin, of their religion, of their identity. But that's not what's happening with anti-Palestinian racism. So the same week that the Prime Minister, and by the way, I'm completely apolitical and deliberately so because I have to speak to people in every party. We need allies in every party. And people can have their preferences as to which party should succeed. And I understand that and lobby for their parties and so on. But I'm expressing an apolitical view. I speak to everybody. But what I saw a couple of weeks ago is that when the former prime minister said, let's not demonize, let's not use Zionism as a pejorative term, and that he's a Zionist, it was the same week that the government issued its guide on combating Islamophobia that incorporated anti-Palestinian racism, and in the footnotes utilized the Canadian Arab Lawyers Association definition of anti-Palestinian racism that basically said that if you fail to acknowledge the Palestinian perspective of Palestine as an occupied land, then you are a racist. So it's absurd. And so we're taking a number of steps to make the points that I've just made to you. And we really do have to resist this. And again, I think it's unfortunate at times when I've heard some rhetoric issued that doesn't recognize that we don't support any discrimination against anybody, but we will not countenance the creation of a model that demonizes us to promote another identity.
To the media, what can we do about, and it's almost all mainstream media with the exception of the National Post, radio, television, social, what can we do about mainstream media and their lack of coverage and distorted and biased coverage of Israel and events happening there? What can we do about it?
Well, first of all, some people have raised with me whether this should be the subject of litigation, and I'm sure that when the committee that I described is set up, that consideration will be given to whether it's a subject of litigation. I'm not sure that litigation is the answer, but I will say that it obviously hasn't gone unnoticed. So, for example, one of our member organizations, Honest Reporting, put together a fabulous brief on bias on the part of the CBC and have brought that to the CRTC. Instead of bringing a legal remedy, have brought it to the CRTC and saying that you are the oversight agency for the CBC. Do your job, address the failure of CBC to comply with its journalistic standards in how it addresses the issues in the Middle East. And in my view, time will tell, but in my view, that's an effective first start. That's an admirable first start. It's an excellent brief that Honest Reporting has prepared, and they've documented the whole history of this at CBC. Good first start, and then we'll see where it goes from there.
In all your years, and especially after October 7th, what would you consider your most successful achievement in this arena, in this area?
So this part of this answer is going to be evasive, and I'll tell you why. I was very proud of being, prior to October 7th, I was very proud of being on the team that intervened in the Supreme Court of Canada to uphold the constitutionality of our hate speech laws. I was very proud of appearing in the House of Commons and Senate committees, justice committees, to advocate for changes that were then required to the criminal code to address hate as an aggravating feature on sentencing, which was adopted, to advocate for a larger category of vulnerable groups that would be protected under that legislation, which was adopted, for advocating for an offense of mischief to religious institutions, which now exists and is now being employed as recently as 2 days ago in addressing anti-Semitism. And so for me, those represent some successes. Right now, post October the 7th, for me, I'm not prosecuting cases personally. That's for the prosecutor, and I'm not investigating. That's for the police to investigate. So my best success can be in education and training and sensitizing those who are in a position to make decisions about the issues that we've talked about tonight. And I try to speak with complete candor, and that is, we're now seeing an increase in a number of criminal charges. We've seen just the other day 29 charges laid against an individual that include advocating genocide, include arson-related, a series of mischief charges. We are seeing some success in law enforcement, but again, to be completely candid, we are so far away from where we have to be in dealing with these issues. So I'm not pretending that I'm not saying to you that that we're resting on our laurels because of all the success we're having. We're trying to create through the criminal law working group, through the litigation strategy that I described, a way to make a very substantial difference in 2025 to what we're seeing. It's very much a work in progress, and to be frank, it's not a happy job at times. It really isn't. I receive a complaint virtually every day from people about hate that they feel that they've been exposed to, and it's not a happy task to have to address these unprecedented levels of hate on a regular basis. But there it is. We all have our obligations to address these things as best we can.
You've been very involved in the Toronto District School Board activities, and especially their anti-Semitism that is being supported. You've been very active in that. Could you talk to us about that and what is happening there? Because this applies to many school boards across Canada.
Well, it does, and I don't pretend to be. I want to be clear. I've been active actually in a more limited way than some of our member organizations that have been really working in the K to 12 space. I've been working much more extensively in the university and campus space, and I can talk about that a little bit more. But in the K to 12 space, one of the things that I think is important is that educators and teachers and trustees in the system actually understand contemporary anti-Semitism, actually understand hatred, and actually understand respectful dialogue. And again, there are people who are involved in this fight that don't always see eye to eye with me on the need to address these things in part through respectful dialogue because they're confronting anti-Semitism on a day-to-day basis. But for example, I'm involved in some workshops that are going to take place this Thursday that involve the TDSB community, where we'll be talking about what hatred means, what anti-Semitism means in its contemporary form, and what respectful dialogue means. And the goal is to open the eyes of people who are otherwise unfamiliar with the issues, unfamiliar with the levels of anti-Semitism that are taking place, or don't understand why it constitutes anti-Semitism. We can't necessarily reach the extremists. We can't. But there is a body, there are many people who come to it misinformed, and those people have to be reached. So that's one of the tasks that I and others are taking upon ourselves: education.
Several viewers have asked about the role of judges in enforcing anti-Semitism charges.
Right. So for me, one of the things that I'm interested in, and I did a lot of judicial education when I was an active lawyer and was on the faculty of the National Judicial Institute, and I have advocated that there should be education for judges on contemporary anti-Semitism by mainstream organizations. And it's not with a view to compelling judges to decide these cases in a particular way, but it's important information for them in the same way as it's important for judges to understand Indigenous history and the issues and how the Indigenous community has been dealt with. It's important for them to understand anti-Black racism. So it's not as if I'm suggesting that anti-Semitism is the exclusive area that they should be educated in, but it's got to be part of the education that is given to every judge. And I'm advocating for that.
And is it not? Is it not part of the
No, no,
education?
no, 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 it's not. Some judges have received it across the country. The vast majority of judges have not. So it's absolutely something that we have to work towards.
One final question. Aaron Brandt, a lawyer in Vancouver, are you familiar with the anti-Semitic legal helpline in BC that
Right.
she's established? What would it take for us to do that so that people have immediate information? We have so many questions here, so many comments. We could be here till tomorrow. People are starved for information and how to take action and if to take action. What would it take for us to create a legal hotline like that?
Well, it's kind of an interesting question because CIJA fields a lot of legal help calls, and I give CIJA full credit for the fact that they field many, many, many calls. What we're doing right now is we're carving off, in partnership with the Canadian Jewish Law Association and with CIJA, what will be the equivalent of such a helpline for criminal law related questions and issues. So that's the start that I can commit to right now. That we'll be announcing the way in which you can contact the Canadian Criminal Law Working Group, and I hope that'll assist in addressing the issue. I can't speak to kind of the availability of an exhaustive legal helpline.
Could it be possible for your organization to create a helpline, a hotline like this? Do you get immediate response?
I'm not going to.
Is that possible?
Is it possible? Theoretically, it's possible. We're probably not the organization to do it. We are stretched to our limits right now. So I don't want to undertake something that I can't perform on. But certainly we'll have that conversation with the organizations that we partner with.
Mark, you've taken on, and you don't need this, I know, at this point in your life, you've taken on an extraordinary task, and you're proving yourself to be a leader and a courageous advocate in this terrible, terrible situation that we find ourselves in. I am, with my full heart, I thank you with deepest gratitude for taking this on. You are one of the leaders, and with you leading, there's hope. I fully believe there's hope.
Thank you so much. I very much appreciate your comments, Doris, and thank you for inviting me, and thank you for those who are participating in tonight's seminar. I look forward to working with many of you, a number of you I know already, and let's make 2025 a year in where we're going to make a very substantial difference.
Absolutely. Thank you again, Mark. Good night, everyone.
Good night.